Welcome to the 5 Dealmaker Clauses webinar brought to you by AIA Contract Documents. This is a webinar regarding 5 key contract clauses every architect should know. Thank you for joining us today. We'll go over a few administrative items before we get started. So this presentation is protected by U.S. and international copyright laws, so reproduction, distribution, and display without written permission of the AIA is prohibited. This course is also eligible for 1 learning unit. Just a disclaimer here that the information that we're going to discuss in this presentation is not provided as legal advice. We always recommend that you contact your legal counsel if you have any questions. So again, this is not meant to be serving as legal advice. And with that, I'm going to turn it over to one of our presenters today, Peter Noon, to introduce himself, and we'll get started with the session. Pete.
Thanks, Hasti, and welcome everybody. As Hasti says, neither Peter Longley nor I are attorneys. We're both practicing architects. I work for the firm Solomon Cordwell Benz in our San Francisco office. In fact, I'm the managing director of our West Coast offices in San Francisco and Seattle. SCB is a multidisciplinary firm. We have architecture, interiors, and planning in-house. Our markets include large commercial multi-use, mixed-use projects consisting of multifamily residential, office, hotel, retail, that sort of thing, mostly in dense urban settings. We also have a very robust practice with educational, institutional work in both student life and academic, and as well as work at airports around the Midwest and around the country. I have been a member of the AIA National Documents Committee since 2016, and I now also serve on the San Francisco AIA Board of Directors. And I'll turn it over to Peter to introduce himself.
Thanks, Pete. So my name's Pete Longley. I'm with CBT Architects. I'm the COO. CBT is a Boston firm, 52 years in business. We're a 200-person firm. We do a lot of mixed-use residential projects, commercial development projects, and we provide both architecture and interior design, and we also provide urban design. We have projects in Boston, in a lot of major cities in the United States, and some overseas. So in any case, I just want to reiterate what Pete said. Neither one of us are attorneys, but I've often been accused of being one.
Thanks, Peter. And so for our learning objectives, most of you on this webinar should be familiar with these. They were in the registration form. But very quickly, we would like to go over a method to establish an effective process for conducting thorough reviews of contracts and negotiating design contracts. We want to review common contractual clauses that are beneficial to the design profession. In fact, this particular one is the 5 Dealmaker Clauses, if you will. Hopefully, we will provide you with some tools and strategies to negotiate some of these clauses, and we will cover other resources that are reliable that you can use to help in your review of those documents. The AIA contract documents have been the standard form documents in the U.S. since 1888. In fact, many refer to them as the industry standard. We like to think that that's the case. We pride ourselves as we draft these documents on their being fair and equitable across the board, whether it's with owners, contractors, as well as architects. And that's because it's a very iterative drafting process that pulls in other stakeholders from the industry besides just the AIA members. We engage with liaisons representing both contractors, attorneys, and owners, and subject matter experts across the country.
So what are the 5 Dealmaker clauses? Some of you maybe perchance saw this is actually a sequel, saw our presentation back, I believe it was in June, and it's probably still available, called the 7 Deadly Clauses. These 5 Dealmaker clauses are by their nature a lot more friendly to the architect, to the design professional. These are tended to be things that you would really want to have in your contract, because if there are challenges elsewhere in your contract, these clauses can help you to overcome them. And with that, we'll just go right into them. The first clause that we have is actually 2 clauses in one. It's 2 different shades of the same thing. There's a limitation of liability language and a waiver of consequential damages. So when we think about the practice of architecture, we wonder, what are the sources of liability, not just to us, but to anybody that's involved in a project. The owner certainly has potential financial risk. There's financial risk to us in doing a project. There's financial risk to third parties who are involved in the project, either using the project or in building it. There's risk that comes from bodily injury or property damage due to negligence from any of the parties who are involved in the project. And then other sources of liability may include willful misconduct, gross negligence, and criminal misconduct. Now, this last bullet here are things that you can't protect yourself with a contract. These are things that can be enforced by the law. They're not going to be covered by insurance. There's certainly risks, but that's more or less not what we're talking about today. We're talking about some risks that may come related to negligence. So what are your client's concerns? His financial risk comes from excessive construction costs, potentially, delays that might impact the project revenues, and we'll talk a little bit more about that when we talk about consequential damages. So his inability to use the project in a timely fashion can begin to impact his bottom line. He certainly has to be aware that there can be bodily injury and property damage caused by a number of people that are involved in his project. And he obviously is aware when he's picking the people who work on the project, he's looking for people with excellent records, but he is aware that he has exposure potentially to negligence or failed performance from any of them. And the way the owner tries to deal with these risks as much as possible is to shift them either by contract or by insurance or both. So now you ask the question, well, why would an owner, or what is this business about limiting liability? What is a limitation of liability? Well, simply, without a limitation of liability, the architect's liability is unlimited. You have to be cognizant of the fact that just because you have professional liability insurance, that doesn't limit your liability. The limits that you carry on your professional liability policy are not a limitation of your liability. They are a limitation of the liability of the underwriter, the company that insures you. So when you think about wanting to limit your own liability, and how are you going to enter into this discussion with the owner, you no doubt start off by saying, listen, I carry insurance to cover my own negligence, and beyond my insurance, I do not have significant assets to cover your development risks associated with this project. I can put my profit at risk, but I can't afford to place my business at risk. Our insurance limits are there to help you out of a problem.
Yeah, Peter, and I would just mention to the folks listening that limits of liability are not impossible to negotiate. In fact, there are surveys out there that show that they're more common than you might think. And really, smart clients understand it's in their best interest to not drive the architect out of business for making a mistake, that it's better to have the architect work with them to solve the problem because that's a quicker and less costly way to mitigate their risks overall. So it's not impossible to get these.
Yeah, the sophisticated owner certainly understands. He starts by requiring that you carry insurance, or he wants to see a copy of your certificate of insurance, because he knows and he understands that that insurance that you carry, that you pay for, is actually there to protect his interests in the event that you're negligent. So the AIA does not have a lot of language available related to limitations of liability. That's partly because the AIA does not want to be seen as self-serving, as existing only for the benefit of the architects who are members of the AIA. But there is some language that's in there, and it's in it's in the agreements that the AIA felt was appropriate. So we start off with a B103, which is an agreement between an owner and architect for large or very complex projects. And if you go into Article 8, Section 813 of that agreement, there's an indemnity provision where the architect agrees to indemnify and hold harmless the owner from damages associated with negligence that's brought upon the owner by the architect's failure in his services. So at the tail end of that clause, there's this statement that the architect's duty to indemnify the owner under this Section 813 shall be limited to the available proceeds of insurance coverage that's required by this agreement. Another contract, and there are only three. This is the second that the AIA publishes with the limitation of liability clauses in the standard text. The B106 is an agreement between an owner and an architect for pro bono services. So this is a contract where the architect provides his services without compensation, without monetary compensation. So the AIA felt it was appropriate to suggest that in that sort of a scenario, that an architect, since he's not being paid anything, certainly ought to have a limitation of liability. So the formula here is a little different. It says in no event shall the aggregate liability exceed, and then there's a fill point for you to fill in a particular dollar amount. And we'll get into the formulas for how we calculate that in a few slides. And then the third agreement is a B109, which is owner-architect agreement for mixed-use residential projects. And again, these are large, complex projects that do carry a lot of risk to everybody that's involved in them. So following the same formula as the B103 at the end of the indemnity clause, we see that the architect's duty to indemnify the owner and the owner's officers and employees under this section shall be limited to the lesser of the stated amount of professional liability insurance required under this agreement, or two, the amount stated in Section 916. And when you go to that section, there's a fill point here that operates under the same formula as the B106, the pro bono agreement, where you can insert in here a dollar amount or some other formula. So what are these formula options? The first option is that you can fill in a set dollar amount. I want to limit my liability to $1 million, $5 million, $500,000. Item two is an amount or a multiple of the fee. For those of you that do work overseas, it's very common over there for design professionals to use a multiple of their fee as a means for computing what the amount is that your liability, that the owner agrees to limit your liability. Number 3 is the amount of insurance that's stated in the agreement. And then number 4 is the amount of available proceeds of insurance, which is different from item 3. So if you've got a $5 million professional liability policy and $3 million of that has been exhausted on another claim that you had that year, and so now you're in for a new claim with the owner, you've only got $2 million left, that your liability is now limited to that. Now, sophisticated owners recognize that limits can be eroded by other claims not related to their project. So some of them will put into their contracts a means to replace the exhausted insurance limits. So that's a way of protecting the amount that they negotiated on. And then item 5 is the lesser or greater of various options. And then I've often seen this clause, but in any case, not less than X or not greater than Y. So you can have a whole variety, a menu of options. I've even seen them where the limitation of liability is 1 and 0.25 times your fee, plus the amount of available insurance. So that's from a very, very conservative owner, but I have seen something like that. So when you think about determining what sort of a formula that you want to see to limit your liability in your agreement with the owner, you need to think about how much liability that you can tolerate, and based on that, try to obtain some sort of a reasonable limit from the client. It's perhaps the amount of insurance that you carry. It's perhaps the amount of profits that you have. For example, if you have $10 million in business and you make 10% profit that year, and you're willing to put $1 million at risk, perhaps uninsured risk, you can think about that. So so anyway, somehow or other, you need to come up with a formula for establishing what you think is a reasonable amount. And certainly the courts are going to want to see that you've established in your contract some sort of a reasonable amount. I mean, if you can't put in an extremely low number that's not commensurate with the amount of risk that's associated with your services. So you need to know the state contract laws where the project is located, and whether to be enforceable, the limitation of liability language must be larger or printed in all caps, or mentioned just above the signature line. Your attorney can advise you of that information. In the state of Florida, for example, the limitation of liability language has to be 5 times the font of the rest of the contract. And you see that in the law, that the law is arranged to protect the interests of the client who's signing the contract, to help. In other words, when your client is limiting your liability, he's not doing so out of ignorance. He's actually seen that clause, he's read the fine print, and he signed up for it. So when you think about those things, the next question you want to ask is, does your counsel suggest expanded language? And we have some of that. Here's a clause that I've seen recommended from attorneys that begin to try to lay out and explain, tell a story. You can almost hear a violin playing in the background, in recognition of the relative risks and benefits of the project to both the owner and the architect. The risks have been allocated such that the owner agrees, on and on. So your attorney may be advising you that you need to do something to help sell the fact that the limitation of liability that you're asking for was a reasonable enterprise for your client to agree to. You might see other suggested language limiting your liability to any cause of action, and you can see a very long run-on list from these things. Again, what does your attorney recommend, especially for the state that your project is located in? You might, if you're working on a project, I saw this from my insurance contract guide. This is language that asks the owner to obtain a limitation of liability from the contractor for your liability. Wonderful if you can get it. I don't know if you can win that one, but somebody seems to think it's a great idea. There have been many cases that I've seen where limitations of liability are intended to flow down to the architect's officers, partners, employees, heirs and assigns, and consultants and their officers, employees, heirs and assigns. So this is just an attempt to show that the limitation of liability is meant to be very, very broad, so that there are no loopholes that would tend to negate the power of the limitation.
So consequential damages, this is the second part of this first Dealmaker clause, if you will. And it's really a separate issue, but in a lot of ways related. So what are consequential damages? Well, you can think of it as direct damages. If you make a mistake and something has to get rebuilt or repaired, that's a direct damage, versus, as Peter mentioned previously, project is delayed to the point where there's lost profits or lost income from rentals or sales. That would be an indirect damage or consequential damages. The thing about consequential damages, they're not always predictable, and they really can't be controlled by you as the architect. They tend to pile on at the end of a job when there's a claim, and it's a runaway train as far as we as design professionals are concerned. And they can far exceed the cost to fix or repair a condition of design, and quickly eclipse all of your insurance coverage. So you really need to understand your risk relative to consequential damages when starting a project. A casino in Las Vegas would have potentially very, very, very high consequential damages for a delay. So you need to know what you're getting into when you start a project. And the other thing about consequential damages, they're hard to define. Generally, it's best to just leave it to the courts. Our position in our firm is we try to get a waiver of consequential damages, and when we get into discussions about what is a consequential damage with the owner, we just say, let's just let the courts decide that. And we trust that, because we're not lawyers, and we could talk about that all day. Next, yeah. So negotiation. How do we get this? Well, first of all, the waivers are usually mutual. So there's usually a mutual waiver of consequential damages. And I often look at this waiver of consequential damages as being very closely related to the limit of liability, because without one or the other, the conditions for catastrophic claims on a project are in place. So if you look to mitigate your risk, look to either get a limit of liability or a waiver of consequential damages, or both if you can get it. But try to get at least one of them. What language that we have in the B101 is a mutual waiver of consequential damages resulting from either party terminating the agreement. And then the exception is if the termination, section 9.7 includes termination fees due to the architect if the owner terminates the agreement for convenience, or the architect is or terminates because the project was suspended. The waiver does not include those termination fees. Again, understand the risk, right? Is the schedule that is going to be included in your agreement, is it reasonable, and can it be adjusted? Can it respond to force majeure conditions like COVID-19? And then, what is, make sure there's a definition of an excusable delay. So things that are beyond your reasonable control, delays caused by others, and so forth. But again, it's understanding the risk as you get into negotiating the waiver, if you will.
So, so Pete, if you've been able to get these measures and these protections in your contract, you might be able to manage your way out of the fact that you might not have a waiver of consequential damages.
That's correct, yes.
Proper scope definition. Boy, this is this one's a really important one, Pete.
Yeah, and it's is a subject of a lot of webinars, because misunderstanding about scope, design professional scope, can lead to a lot of misunderstandings and potential claims. So it's in everybody's interest to define your scope properly. And what is the proper scope do? Well, first of all, it facilitates the owner's vision for the project. It informs the project design costs for the owner, so they can put together a pro forma or their development expenses, and it's the basis for your fee. So you need a good project description. You need to just define the services that you're required to provide for the project, and you need a good schedule that you can count on and look back to in the agreement.
Time is money.
Yep, that's for sure. And I would add that clients in the end, they're looking for they want to attain their project vision, they want to control their costs, and they want to meet a schedule, but they also in the end they want an all-inclusive agreement so they don't have to incur unforeseen costs down the line. So the clearer the vision of the project, the definition of the scope and so forth, the easier it is to define what you will and won't do as part of your agreement. But we find that there are often very squishy understanding on the part of the owner what their project is even all about, and then it's really hard to define the scope. So it's in everybody's best interest to provide clarity to the owner's vision. What do we want as architects? Well, obviously we want a mutual agreement that sets a definitive scope. We want to avoid open-ended commitments to issues. We don't want to have to redesign forever. We don't want to have to provide services forever, or having open-ended potential for schedule extensions. We really want to avoid taking on such things as any and all necessary consulting services. Things may pop up on a project long after you've agreed to a fee that could take you by surprise, and if you're agreeing to take on any and all, there may be some things that come up down the line that you'll be stuck with that you hadn't taken into account for your fee. And we obviously don't want to provide services to fix or respond to the failure of other parties, other consultants that the owner may have hired outside of your agreement with him. So what do we want? Again, a clear definition of what constitutes additional services, which are a departure from our basic services. So, how do we negotiate that? Well, it's easy to say, look, my fee is based on a project, the schedule, and my scope of services. So let's work together to find a way to be on the same page relative to the magnitude of each one of these. you can also say, look, I can't agree to hire any and all consultants that you might ever need. We could discover things later on that we just don't know today. So let's work together and go over a comprehensive list of the disciplines that are needed for the project today, and we'll make our best judgments as to what we have to have and the consultants we need to bring on. And we can manage our own services, but we have to depend on the rest of the team performing and managing their services. So if they create more work for us, and I can't control that, then we need to be compensated for that as an additional service. And then, clearly today we don't know enough about the project, so we may have to work initially on an hourly basis so that we understand the project better. I know in our firm we often work hourly on, sometimes we call it project definition studies, but we found that most owners are open to that type of arrangement within limits because it allows us both to be more certain of the scope of the project going forward. And it's a good way for them to risk a small amount of money on a study to define the overall project scope and save a lot of problems potentially down the line. So the AIA has pretty good text in it in the B101, which is sort of the workhorse owner architect agreement. Article 3.1 defines basic services. So anything not set forth in Article 3.1 is then either a supplemental or an additional service. In the B101, again, in Article 4.2, it states that the architect can provide additional services after executing the agreement without invalidating the agreement. That's important to have on hand. There's an important clause to have in the agreement so that you're not risking invalidating the agreement later on when the scope changes and you have to get additional services. And then finally, one place that we found where scope creep happens quite regularly is in the construction administration phase, or construction phase services. And that's because a lot of what's going on is outside of our control. Again, the contractor at that point has taken over the job, and frankly, they're the big fish during construction because everything that the project depends on what they're doing. And so what we found is that in CA, everybody looks to the architect to do whatever is needed and has no limits to its services, but we have to do whatever is needed to keep the job moving forward. So in the B101, there's a nice little series of boxes where we put specific limits to some of the time-consuming services that we would provide in CA, such as shop drawing review and visits to the site, inspections, and so forth. And then finally in 4.2.4, defines the schedule for the construction, and that's important as well because when that schedule is extended, it can certainly affect our fees for the project. So 4.2.4 would give a certain amount of time after substantial completion of the work where we're obligated to provide construction phase services, and that anything in the agreement between the owner and the contractor that extends the date of substantial completion in the owner architect agreement should be compensated as additional services.
So Pete, this is simply saying that for 60 days after substantial completion, which is the date on which the owner can legally occupy, you'll be willing as a part of basic services to go back and review cleanup of the punch list.
Right.
This is correct. That the builder ought to be able to get that punch list cleaned up and everything done in 2 months.
That's correct. And then there's what some refer to as the sunset clause. And this basically says that any services beyond a specific date would be compensated as additional services. And this is good to know when the obligation to provide services ends. It's good for the owner to know that, as well as we, the design professional. And it reduces the potential for unlimited extensions of, going back to the previous clause, substantial completion, just moving months and months ahead. At some point, the sunset clause would take effect to help mitigate some of those, that scope creep for the architect.
And I think it's worth noting that both in 424 and in this 425, the issue is not that your services terminate or end at a certain date or at a certain point in time. It's just that beyond that certain date or that certain point in time, you're going to be paid additionally to the amounts that you've listed in your agreement for basic services.
Right. And then it's important to document, obviously, the scope in your agreement, and that doesn't always match the scope that you might have had in a proposal or other discussions with the owner. So it's important to note that the agreement supersedes prior negotiations. And I don't know how many times I've had conversations with our project managers when they say, but in our proposal we said, and I always have to tell them, well, it doesn't matter what's in the proposal, what's in the agreement. That's what's going to govern. So what do we want to look for? I think and it all comes down to it, it's always easier and best to focus on the services that we will provide, rather than try to define all of the things that you won't do as basic services. That's why in the B101 we talked about Article 3 lists all of the basic services that we'll provide, and anything not in that Article 3 would then be considered additional service or a supplemental service.
Yeah, and I just want to emphasize the word specific, because attorneys are compensated for every hour that they work or every fraction of an hour. Architects attempt to measure their cost against the time, but architects' contracts are not usually hourly. They can be, but they're not usually. They're more focused on producing a product, however long it takes. And that's a very scary thought. And so you need to try to find some way of being as specific as you can about what it is that you're going to do for the dollar amount that you're agreeing to that covers basic services. And I think it's probably best to just simply say it's better to focus or limit what you will provide rather than try to define what you will not provide. What you will not provide could be an infinite list. So AIA's approach is the services that are listed in this Article 3 are the basic services. And they don't bother to say, and that's it, but that's implicit. So our third clause is suspension of services for non-payment. So the real question, when we find ourselves in a situation where the client has not been paying us, the question we have to ask is, should we keep continuing to provide services without being paid? Well, what are the client's concerns? He'd love for you to just keep working without getting paid. He wants you to meet the schedule. He can't afford for the architect to stop for any circumstance. Now, the owner may be awaiting for funds to flow in from some other source to be able to pay you, and cash flow amidst all of his many other project expenses, many of which might be much higher than yours. These are all things that he's juggling when he's thinking about when he's got a limited amount of money and who should he pay first. What does the architect want? Well, we want to make payroll. We want to pay our consultants who, for the most part, and it's not true, this is not true in every state, you need to check your state, but many states allow you to set up an agreement with your consultants that they are paid when they can be paid only after you've been paid on account of their services. And lastly, you want to be able to pay your bills, whatever all of your other bills are, your rent, your lights, your insurance. You need to get paid. You often see this sort of an approach in negotiating with a client. You say, listen, I will need to pay my bills. My consultants will want to stop. I can't afford to finance your project. I need to have some sort of a clause that that can allow me to stop if you're not paying me. So can we agree on some reasonable payment provisions?
Yeah, and Peter, I think in our experience, a lot of times the discussions around this tend to all of a sudden diverge and focus on things like disputed invoices or disputed sums owed to the architect. And these are matters of law. They don't need to muddy the waters of an agreement. And then other times discussions focus on the owner's ability to withhold funds to cover alleged errors and omissions, and that was one of our 7 deadly clauses. But to suffice to say that that's not a good thing to have in your agreement. So when you're talking about the suspension of services for failure to pay, try to keep it focused on paying legitimate invoices and not worry about whether it's disputed or not, because they don't have to pay you for disputed invoices, and try to avoid in all cases any kinds of discussions about withholding fees for errors and omissions.
So the AIA standard text is found in Article 9.1 of a B101. If the owner fails to make payments, such failure should be considered cause for suspension of performance of services. Now, in the event of suspension of services, the architect shall have no liability to the owner for the delay or the damage that's caused. And then before resuming the services, the owner shall pay the architect the amounts that were previously due. And lastly, the architect's fees for the remaining services and time schedule shall be equitably adjusted once you've been paid and you're getting going again. That's a really good language. So what to look for in a suspension clause? Elsewhere in the contract, you need to negotiate a reasonable payment period after the invoices have been submitted to the owner, because this establishes the basis for your ability to be able to trigger the suspension clause. And beyond, once you have this language in place, you really need to consider what is your company policy for enforcement of it, because telling a client that you're going to stop working that's a big deal, and you need to think about what are the circumstances under which you really want to exercise that contractual option, and try to be consistent about it across the firm.
Yeah. Now our next clause is dispute resolution. So in most cases, 95% of cases, disputes are resolved before they go to trial, and it's often after a lot of back and forth amongst lawyers and mounting legal fees. So it's always best to try to resolve issues at the negotiating table early on. And everybody will tell you that disputes resolved quickly save time, money, and energy for both parties. So what do the clients want to, what are their concerns? Well, they want to control the process. They want to eliminate trials by jury. They usually want arbitration in lieu of litigation. They want to be able to consolidate and join disputes or claims amongst a number of parties. Now, state agencies...
Contractor, right?
Yeah, exactly. Typically the contractor. State agencies, they often have their own dispute resolution process, and foreign clients often will dictate the law and the process which may be completely different than it here is in the U.S. So the governing law and the venue is very important as you're considering all of this in your agreement.
Yeah, the clients want the suit to be in their local court.
Yep, and they want to also, the clients want to be able to preclude claims for anything other than payment of sums due.
Yeah, you have to be very careful. This is a very subtle clause, because when you see this sort of a clause, that means that the owner has just gotten you to agree to the only thing that you can ever collect from the owner is your fees, and he therefore has no liability for any bad acting, such as misuse of your instruments of service. So this is something that you have to be very careful about when you're negotiating, limiting dispute resolutions.
So then we have to think about, well, what are we looking for as the architect? Well, first and foremost, we want equity in the process. We want to be able to deal on an equitable basis and resolve claims. We want to understand the governing law and venue. It's usually in the architect's best interest, and in the AIA always puts this in first, is to go to mediation before any binding dispute resolution. Mediation costs less than litigation or arbitration, usually takes less time, and many architects may receive a credit from their insurer if they include mediation language in their agreements. You might get a credit or a reduction in your fee. Architects typically prefer litigation over arbitration. It's pretty much a knee-jerk reaction in most cases, because arbitration does not generally follow, or an arbitrator is not required to follow the rules of law. And so that is something that isn't always friendly to the design profession. But you want to consult your legal and insurance counsels about all of the specifics of that in whichever venue you would be in. The other thing is that we want to make sure that we don't have consolidation of a dispute between the owner and us with a dispute between the owner and the contractor. And this is specifically can be very confusing, because the contractors, standard of care, if you will, is perfection. They have to deliver a product that is without defect, while our standard of care is not perfection. It involves some level of imperfection, and that can be very confusing. And judges would have to, an arbitrator would have to wear two hats if a claim between the owner and a contractor was consolidated with a claim between us and the owner. Arbitration is not always less expensive than litigation. Arbitration can cost a lot of money when you pay all the fees and for the arbitrator and the experts involved. It can be just as much as litigation. And the thing that we're always most concerned about is arbitration rulings are almost impossible to appeal. So we try to avoid that, but not always able to do so. And then how do we negotiate all of this with an owner? Well, the first thing is we need to identify and agree on a dispute resolution process. That's important in any agreement. Look, mediation is going to save us both time and money, and it's not a final decision. If we can get to mediation and agree, that's great. But it's not binding on the parties. So if we can't agree in mediation or can't agree to a settlement, we can always go to some form of binding dispute resolution. Mediations are now done virtually, especially with COVID, so we don't have to travel. Especially if you're doing, working with a client from a completely different side of the country, like we always do, and then the project is in a third location. Having mediations done virtually is a godsend in a lot of ways. And then the thing to be careful about too is when we negotiate, we want to make sure where the or the venue for the governing law that's going to govern the contract. And it's not, you know, architects generally understand the codes and the laws as it relates to their design, but often overlook the governing law and the venue where the contract is going to be enforced. And Peter brought up in New York, and I'm from New York and I didn't even know this, but there is no statute of repose on an architect's error or omission. So statute of limitations is the amount of time that it takes for an error or an omission to be discovered, and that's often not, there's often a limit to that, but the statute of repose is the amount of time that the owner has to act on that. And if it's unlimited, you could be, you know, find yourself in a claim 20 or 30 years down the road when somebody finally decides that it's time to get some additional insurance money on to help pay for some bills. Good sample text in Article 8 of the B101, again, the workhorse owner-architect agreement. In Article 8, it establishes the terms of that article as the means to settle disputes. It limits the time period for claims. So that's often a way to counteract an issue with states that don't have a statute of repose. The architect indemnifies the owner for its the architect's negligence, acts, and omissions. It establishes mediation as a condition precedent to binding dispute resolution, and then it establishes the rules and venue for that mediation. And then there's a checkbox where you can elect to choose arbitration or litigation as binding dispute resolution. What do we want to look for relative to dispute resolution? So first of all, we want to watch out for any agreement to consolidate or join your dispute with that of another party, especially the contractor, and should include common questions of law or fact. And then whatever agreed dispute resolution method we have should survive termination. So in other words, if the owner terminates for convenience or we terminate an agreement for cause, you still want to have whatever method of dispute resolution remain in place for any subsequent claims by either party.
All right, we come to our fifth and final clause, the architect's right to terminate for cause. So any agreement should include provisions for termination by the parties. That's just a factor of life. A contractual relationship may have an end date, and you may decide going into it, it's time for a contract to be over. There should be provisions that allow the parties to terminate that agreement. Now, the right to terminate for cause gives the injured party the ability to stop services in the face of a harmful relationship, to potentially recover expenses and fees, and lastly, to enforce contractual provisions that arise or fall out of or result from the termination. Your client is concerned about having complete control of the project. They want the ability to terminate for cause with penalties and furthermore, with unfettered use of the design with a replacement architect. This is clearly, Pete and I have negotiated many contracts with our clients, and we know this is a very common ask coming from them. They want the ability to terminate for convenience, and actually that makes sense. They decide that they want to not do the project anymore. They can terminate for convenience. Many will have you cooperate with whoever replaces you after you've been terminated. That can be a very testy clause. But bottom line is, and I've seen this too many times, they do not want to give the architect the ability to terminate them for their failures. And well, anyway, I think that's a statement that stands on its own. So what does the architect want? The architect wants to control its own destiny. It wants to use termination for cause as a cudgel. That's a short stick you use to move a horse along, to use as a cudgel when negotiating a dispute. And we want the ability to terminate the owner for cause. We, on the other hand, are likely unconcerned with termination for convenience. Frankly, I don't imagine any owner would want to allow an architect to terminate them for convenience. Think about it this way: your last chance to terminate an owner for convenience is before you decide to enter into a contract with them. So how do we approach this? We're simply looking for fairness. The owner has the right to terminate. We should have the right to terminate. So that's not too hard of an ask. AIA has termination clauses in all their owner-architect agreements. This one is wrapped into the business of non-payment that we talked about earlier. That if the owner fails to make payments, the architect has an option to suspend. But we also have cause for termination if we feel that's severe about it. Here's another clause that's also in Article 9 of a B101, that either party may terminate should the other party fail substantially to perform in accordance with their obligations in the contract. Also, we see that if the owner suspends a project for more than 90 days, 90 cumulative days, the architect may terminate. Or in 9.6, if the owner terminates this agreement, this is a good provision to have for you, by the way. If the owner terminates this agreement for convenience or for its convenience, or if the architect terminates this agreement pursuant to 9.3, which we see right above there, that the owner shall compensate the architect for its services performed prior to termination, reimbursable expenses incurred, and costs attributable to termination, including the cost to terminate consultant agreements. And additionally, a 9.3 termination entitles the architect to a termination fee, which is listed in section 9.7 if you go ahead and negotiate that. Something to think about that goes along with the issue of termination. Keep in mind that the architect grants the owner a non-exclusive license to use our instruments of service. Well, if the architect rightfully terminates for cause, that license shall terminate. Something very important. So what to look for? We're looking for fairness. You should have the same rights that your client wants for themselves. You have to think about your liability after termination, particularly the owner's use of your instruments of service without your involvement, and you need to address that. You need to think about whether or not you want your firm's name to be associated with the project after you terminate the owner. And then you may be faced with walking away with outstanding amounts due. So before you do that, you need to be mindful of your consultant's interests, since they have a pay when paid issue. You probably don't want to terminate for cause without talking to your consultants first, because that's not just your decision to not get paid, but it's your decision for your consultants to not get paid.
So with that, I want to again thank our presenters for an excellent presentation, and thank you all for taking the time to be with us today. Have a great afternoon.